All right, so welcome to Company Law. We are still discussing corporate finance. We are now transitioning from discussion of shares to debentures. Yeah, so you spend quite some time discussing shares. So we are looking at another aspect of corporate finance, what they call debentures. And another way of describing debentures is what we call like the loan capital, if you like. Loan capital, that is a capital which the company has raised by borrowing. And at some point, the money will go out of the company. Unlike shares, where the money contributed, apart from redeemable preference shares, may stay in the company for as long as the company remains, as the case may be. So we will first of all try and define what a debenture is. So once we know what a debenture is, then we come and look at the specific rules regarding how to issue debentures, the evidence of you being a debenture holder, and also how to secure your interests. If you are a creditor of the company by way of debentures, you may want the company to use some of its assets as a security for you. So we come and discuss all this. And as I told you, company law, the law itself is the act, and any relevant decided cases as may be there. So we will be discussing the law itself. Then as and when it's necessary to make reference to case law or some jurisprudence, then we do that in that regard. So I would like us to go to the first schedule. As I've told you before, if you want to know the meaning of a word which is not common in any legislation, you must first try and find out whether that legislation has got what we call interpretation session. If it has got interpretation session, then you look it up, whether that particular word is defined there. So let's go to schedule 1. We are going to the first schedule. We'll come back here. Put it this way. First schedule. Yes. Let's put it 301 and see. Yeah, so you know they have like the first schedule here, and as we've looked at it before, this was the first time. So first schedule, section 383, definitions. Because we go to section 383, we will be told, and I read. So section 383 is headed interpretation. In this act, unless the context otherwise requires, the expression defined in the first schedule have the meanings assigned to them in that schedule. So this first schedule is actually part and parcel of section 383. Just because section 383 will be too long, that is why the legislative drafter has actually created a separate place for listing the various words and their meaning. So section 383 is the interpretation section, and then the details of section 383 have been adumbrated for us in the first schedule, as we are saying. So now, the word of interest in this legislation is debentures. So we quickly know the words are arranged just like a dictionary in alphabetical order. D, so you move quickly to the D column to try and locate what it says. So here, we are told that debenture includes a written acknowledgement of indebtedness issued by a company in respect of a loan made or to be made to it or to any other person or company, or money deposited to or to be deposited with the company or any other person, or the existing indebtedness of the company or any other person, whether constituting a charge on any of the assets of the company or not. So this is the meaning of the word debenture. One observable thing about the way Section 3.3 and the first schedule of Act 992 have defined debentures is that we are giving a general explanation in terms of description of what a debenture looks like. So we are told that, but if you look at the word, the opening words, it said debenture includes, and in statutory interpretation, whenever a word is being defined and is preceded by includes, what it means is that whatever is being provided there is not exhaustive. You are only being given some of the instantiations or some of the examples of what amounts to whatever is being defined. So in this particular case, we are talking about debentures, and we are being told that debentures include all the following, A to H. A to H, and notice that H has also got its own sessions. So all the things which are listed in A to H are instances of debenture, but the A give us some reasonable definition, and that should help us to determine what other members could be added to the list. So A says that debenture includes a written acknowledgement of indebtedness. So that is the bottom line. Debenture is a debt, as I said, but it's a debt which is evidence in writing. So you cannot just say that you're a debenture holder and you have no document to prove it. If the company is owing you by word of mouth, yes, you may be a creditor of the company, all right, but for the strict purpose of debentures, you would not be treated as a debenture because your debt you have against the company is not evidence in writing. And the law is quite explicit that a written acknowledgement. So the company will give you a document in which the company itself has written acknowledging that it owes you. It owes you the loan you are giving to it, or the loan you are about to give to it. Or maybe if you've deposited the money with the company, for the company to work with it for a period, and then they'll pay you interest or whatever, it can also suffice as a debenture. But the critical feature is that a debenture is a debt which is acknowledged in writing by the company. And that's the most important thing. So let's keep that in mind. Another takeaway from the definitional attempt in A, which we have seen, is that the debt which the company has acknowledged in writing as owed to you, the debenture holder, may be secured or unsecured. So if you look at the latter part of the A, whether constituting a charge on any of the assets of the company or not. So the debts the company owe you may be secured, in which the company has provided the security to assure you that should the company default, you have something to fall on in order to get your money. So let's keep that in mind. Then B, debenture includes debenture stock. Debenture stock. Debenture stock, when we go to the substantive provision from Section 83, we will be explaining it further. But the debenture stock is what you call like a block of debentures, if you like, block of debentures. We use the analogy. There used to be a type of bread in Ghana, which we call like the polo. No small no loaves of bread, and they are no string together. But when you are selling it, you just punch or plug a small portion of, and that way. So if you like, the debenture stock is a block. It's a block loan, so to speak. Then we also have a convertible debenture. Convertible debenture, a debenture which may be converted, to become a share, as it were. So they can transition from being a debt to a share. The holder will not be a debenture holder. The holder may become like a shareholder, as the case may be. Another example of debenture is a bond or an obligation. A bond is nothing new. It's something that you know already. In law of contracts, when we were learning about penal bonds, remember penal bonds, which led to the emergence of the form of action we call the assumpsit. So it's the bond you are talking about. So a bond is simply a solemn acknowledgement of an obligation by the company towards another person. So maybe the company has taken the money from you, 100,000, and they said, okay, they will pay you 20,000 extra. So they make a bond saying that they acknowledge that they have an obligation to you to pay 120,000. So their interest will have been worked into it already. So that is what it has acknowledged formally. That so a bond is an example of a loan stock. A loan stock is also example of indenture. Of a debenture. Sorry, a debenture. And loan stock is, I mean, some of the terminologies for example, loan stock and debenture stock can be interchanged, and the import is essentially the same. And an unsecured note. An unsecured note, the company gives you a debt note saying that, yes, it owes you, but it's not charged to any security. That is also debenture. Or G, any other instrument executed, authenticated, issued, or created in consideration of such a loan or existing indebtedness. Yeah, so not only the loan itself, any writing, that is instrument, which is made because of a certain loan arrangement between you and the company, will also be treated as a debenture. That notwithstanding, there are certain debt arrangements which have the appearance of a loan, and for that matter, that should have been treated as a debenture. And yet, the law is saying that those transactions or those instruments of writing do not count as debentures. So if you look at H says that no the starting said debenture includes, and then A said that but does not include I, a bill of exchange. You know, bill of exchange, and the bill of exchange act at 55. A promissory note, a letter of credit, acknowledgement of indebtedness issued in the ordinary course of business for goods or services supplied. So maybe you supply goods to the company signs the invoice or delivery bill or way bill or whatever, which shows that yes, the company has actually acknowledged that it has received these goods from you, the supplier, and that it owes you so much. Now, on the face of it, that looks like a debt arrangement, but the law is saying that it is not the type of debt which will count as a debenture for purposes of corporate finance. So let's keep that in mind. And then just before we move on to the VA and the rest, let me remind you of, if you look at the I, bill of exchange, promissory note, right? Letters of credit, LC. Now, these are debt instruments which are specially regulated. So we have like the Bill of Exchange Act, right? Which governs all these various negotiable instruments. So they have their own separate legal regime. And that is why, for purposes of corporate finance, they are not treated as debentures. Then V, a policy of insurance. If the company has issued insurance policy to you, you pay your premium. That is a sort of like a debt, so to speak. But because insurance policy has also got its own different legal regime and legal framework for its regulation, it is not treated as a debenture. Particularly so if you have like maybe a company which is an insurance company, of course, its own insurance company which can actually issue the insurance policy. Now, the company is licensed to do insurance business. So you take insurance policy. That is a sense, a claim that you have against that company, that is insurance company, should any of the specified risk occur. So that is a sort of claim against the company, and that will be some form of like a debt, so to speak. But it is not treated as a debenture you have in that company, because we have the insurance legislation which governs these matters. And VI, a deposit certificate, passbook, or other instrument, other similar document issued in connection with a deposit or current account at a banking company. So maybe you have like a company which does a banking business, taking and accepting deposits and all that. So people go and deposit money, either fixed deposit or usual savings and current accounts deposits. So you are given a document which is an evidence that you have deposited 10 Ghana cedis in the particular bank. So that is a claim you have against the bank. As far as the 10 cedis is concerned, you have the evidence. But that is not treated as a debenture. You cannot say that because I deposited 100,000 in bank X or bank Y, I am a debenture holder against that bank. No, that will be conceptually flawed. That will be abuse of legal jargon. And that is why the law is saying that those things do not count as debentures. I will go back and then discuss the specific rules, having now be clear in our mind what debentures are. Good. Yeah, so we want to know how the company may give out, that is, issued debentures or debenture stock. So Section 83(1) is quite instructive that a company may raise a loan capital by the issue of a debenture or of a series of debentures or debenture stock. So as I indicated, you can have let me see if I get something to write here. Okay, so debenture, if you like, just a single debt acknowledgement. So single debt acknowledgement. You just written it. And then we also have like the debenture debenture stock, where you have like the multiple, like a multiple debts acknowledged, or let me say the multiple single acknowledgement of multiple debts, if you like, let's put it that way. So maybe practically, let's say that we have we need to raise the company needs to raise a loan of 100 million Ghana cedis, right? The company may not find it easy to get the what do you call it, an individual or an individual to give a loan of 100 million. So maybe it may not even get the one company, one bank, because the 100 million is probably a substantial fraction of the city capital of a financial institution. So you may get two or three banks or individuals. They may come together and say that we are going to give this block. Then the the company may have to, let's say, structure. Okay, we need 100 million, but we know that 100 million is difficult for an individual or entity or a person to make it available. So we have this a block debt of 100 million, and we have like the acknowledgement written for the whole of this. So you get various individuals or entities who contribute various amount to get the 100 million, but they can get what we call like a trustee or somebody whose duty is just to hold the title in respect of the debts and manage the interest and collection and everything for the benefit of those who contributed the debts. Like, so that is also possible. But the bottom line is that with respect to the debenture stock, you're talking about, you needing or the company trying to raise a huge debt, which it cannot get maybe an individual debenture holder to actually contribute. So you try to get that block, and within the block, you have smaller units in there. And each unit of debt can be taken by an entity or by an individual. But because the company may not probably have to deal with all the maybe thousands of, or hundreds of, individuals or entities that contributed to that huge block loan, you get someone who will be like a trustee sort of to stand in and manage the debt claims which the individuals may have against the company for on their behalf, as it were. So that possibility is also there. The user. Hmm. Good. 83.2, the debentures of the same series shall rank at the same rate in all respects, although they may be issued on different dates. Yeah, so if you have, just like the example I also gave, like you have a series of debentures. Maybe you have, okay, we have 10,000 CDs. We are going to have 10,000 debenture series. We need probably 100 of that, okay? So 10,000 times 100, that will give you how much? Is that about 1 million? Good. So you have debenture series in respect of in amounting to 1 million Ghana cedis, but it is 10,000 Ghana cedis each. So that is the debt you are selling, or you want people to come and take and give you that money. Then you acknowledge that you owe them that amount of money. And let's say that the 10,000 is going for interest of 20% per annum for the duration. So that is it. But the 100 units of the 10,000 debenture you are prepared to give out, you may not get all of them being taken at the same time, because people will be coming for them at different times. So that is why 83.2 is saying that yes, so long as they are of the same series, in this case, 10,000 Ghana cedis, debt at the interest rate of 20% per annum. So that is a series. And even if they are taken at different times, it will not affect the interest rate, which is supposed to be paid for each of them. And instead of issuing debentures acknowledging separate loans to the company, the loans will be funded by the creation of debenture stock of a prescribed amount, parts of which represented by debenture stock certificates may be issued to separate holders. So the 83 3 is explaining what we mean by the debenture stock that we'll be talking about. So as we indicated, you need 100 million, but the 100 million, you may never get one person or one entity to come and take it. So you have like the 100 million block loan or debenture stock, and within the 100 million, you say that okay, you have like 5 million, 5 million, 5 million acknowledgement. So that's about 20, right? You have about 20 units of 5 million Ghana cedis debentures, which will constitute that 100 million. So if anybody or any entity comes and take one or two, he or she will get a certificate, but his certificate forms part of the block loan that we talk about, the 100 million. So that is the 0.83 selling us. So creation of a debenture stock will have to follow some formalities. It's created by deed. Now, when we say a deed, you know what we mean. A deed means that it has to be a solemn execution. It will have to definitely be in writing. It will have to have the seal of the company on it. And as we know, a deed is such that there's no need for separate proof of consideration. A deed is enforceable on its own terms. So the debenture stock shall be created by deed under the common seal of the company, or certified by the signatures of two directors and the company secretary in the form of a deed poll or of an indenture in favor of trustees for debenture stockholders. Yeah, so it's a formal acknowledgement, and for that matter, once the instrument is made, it can be enforced against the company without any further proof that come and prove to us whether you actually gave the loan to the company or when did you do that. No, all those things will not be necessary because it's a deed, and the deed has all the requisite formalities. And that is why we are told that either it has a seal of the company, or if you are not using the seal of the company, it must have a certified signature of two directors and then the company secretary. And mind you, it talk about certified by the signatures. So you have like the top officials of the entity saying that yes, we acknowledge that this company has actually taken so much from this person or that person on this day or on that day at this rate and so on. But an important point which we need to underscore is that whereas a shareholder is a member of the company, a debenture holder is not a member of the company. So that is very important. And that is why I said that another way of mentioning a debenture is to say, if you like, the loan capital or debt capital, as it were. So shareholders, to use an ordinary man's language, they are the owners of the company. So as I said, that is not the appropriate corporate law language. But just to give you the sense that shareholders, they have like a permanent stake in the company. Debenture holders, they are not members of the company. Even if you have a provision in the constitution of the company that they are members, the law is saying that they are not members. And not being members, they do not have the right to attend and vote at general meetings of the company. So that is important. Again, where there's a contract between the company and a prospective debenture holder, that is someone who intends to give money to the company, that contract is enforceable like any other contract. And for that matter, specific performance is applicable. So section 84, a contract to the company to take up and pay for any debenture of the company may be enforced by another for specific performance. So the company has actually entered into discussion with you for you to give money to the company in the form of like a loan, capital, a debenture. And after everything is done, you become not forthcoming, you are no longer interested, the company can go to court and specifically perform the contract so that the court will compel you to honor the obligations that you have undertaken. The same thing applies to the company. Don't forget that equitable principles are supposed to satisfy what you call the mutuality principle. It should work both ways. So if the company can enforce the debenture contracts, or the contract to take out the debenture against the prospective debenture holder, in much the same vein, the debenture holder can also enforce it against the company, so that if the company has a change of mind and say that we are no longer interested, and despite the fact that the contract has been made, he too can go to court and get it enforced against the company. Now, how do you prove that you have a debenture in the company? In the case of shares, we notice that the company must give you the share certificate within and in 2 months, and the share certificate is an evidence of ownership of the number of shares stated on the face of it. So we look at all that. And when it comes to debentures, so Section 85 is to the effect that, subject to the Central Security Depository Act 2007 at 733, the company shall, within 2 months after the allotment of any of its debentures, or after registration or the transfer of any debentures, deliver to the registered holder of the debentures or a certificate of the debenture stock under the common seal of the company, or as certified by 2 directors and the company secretary of that company. Now, this is pertinent because, company is an artificial legal person. The officers may change every now and again. So therefore, if you had previously given a loan to the company in the form of debentures, as we have explained, you need to have a proper evidence which you can rely on to assert a claim against the company with respect to the debenture. And the proper evidence you can have is the debenture stock certificate, as it were. And that is why the law says that within 2 months, you must have the certificate issued to you. Now, if you don't handle the certificate well and it becomes defaced or it gets lost or is destroyed, you can have it reissued to you, provided you pay the prescribed amount of money which the company will have stipulated. And let me emphasize that you don't go to the registrar of companies to get your debenture store certificate. You don't go to the registrar of companies to get your share certificate. You get it from the company itself. So let's keep that in mind. Now, what is the legal effect of the statements contained in the debentures? Mind you, we've already noted that a debenture is a formal acknowledgement of what? Indebtedness. Now, so where the debenture, the written acknowledgement is produced, and we see things written therein, what legal effects do they produce? So Section 86 makes the point that statements made in debentures or debenture store certificates including statements made electronically, are prima facie evidence of the title to the debentures of the person named in the statement as a registered holder and of the amount so secured. Yeah, so the fact that your name is mentioned on the face of the debenture, in absence of contrary evidence, the default position will be that you are the owner of the amount of money signified by the particular debenture, as it were. Now, there can be consequences because just as a person can use a share certificate to go and raise loan or do some other arrangements, in the same way, a person can also use his debenture certificate to go and raise a loan or do some other arrangements. So what happens where Company A has given you a debenture certificate saying that the company acknowledges that it took 1 million Ghana cedis from you, and that an interest at the rate of 20% will be paid to you within 5 years or within 10 years. Now you take that certificate, you go to a financial institution, or you go to any place where they do credit sales, right, transactions. Maybe you buy a car on credit or a mortgage or a house or whatever. And you give the debenture certificate you have to them as an evidence of your ability to actually pay. So they take it as a security. So they look at it and everything looks regular on the face of the certificate, and they said, okay, it's true, this gentleman is having a debenture of 1 million Ghana cedis, and if you even calculate the interest, which will accrue over the period, it's going to get altogether about 2 million Ghana cedis. So we like to do business with him. So they give you a facility or they give you something on credit. Now, if you default or something and they decide to enforce the debenture certificate as part of the whatever security arrangements that you made with them at the time that they gave you the loan or they gave you the car or the property, and they get to know that the information stated on the face of it are not accurate. And as a matter of fact, you did not give 1 million really to the company, you gave 100,000 Ghana cedis. But they made a mistake. Instead of writing 100,000, they added another zero for you to appear as 1 million. So that is what section 86, subsection 2 is speaking to, that where a person changes the position of that person in reliance in good faith on the continued accuracy of the statement made in the debenture or debenture store certificate, the company is a stop in favor of that person from denying the continued accuracy of the statement and shall compensate that person for a loss suffered by that person in reliance on that accuracy, and which that person would not have suffered had the statement been or continued to be accurate. Yeah, so section 86(2) is doing what we also have under this section 26, estoppel. That yes, the statements contained in the debenture constitute an estoppel against the company in favor of the third party who is relying on it. So the company or whoever gave the loan or the credit facility to the other person and is now seeking to enforce the debenture will be allowed to get whatever that it says, despite the fact that there was a mistake or there was an error. And for that matter, the content is not really accurate. The law protects the third party, and legitimately so. The third party should be able to put reliance on it. But all is not lost for the company. Section 86(3) says that where the company has actually paid the actual amount stated on the face of the debentures to the third party and the interest and all that, the company can exercise the right of indemnity. Can exercise the right of indemnity and sue the officer or director or whoever is in the company whose action or inaction resulted in inaccurate statement being stated on the face of the debenture, which has been enforced against the company because of the estoppel. Now let's look at some types of debentures. We have perpetual debentures, convertible debentures, secured and non-secured debentures, what we call like a naked debentures. So let's look at each of them in turn. Perpetual debentures. Section 87 is to the effect that a condition contained in a debenture or in a trust deed for securing any debenture shall not be invalid by reason of the fact that the debentures are by that condition made irredeemable or redeemable only on the happening of a contingency, however remote, or on the expiration of a period, however long. Now, Section 87 should be put in a proper perspective. Remember, when we started discussion of debentures, we made the point that unlike shareholders who are members of the company and whose money, apart from maybe redeemable preference shareholders, will have their money remaining in the company for as long as the company remains. When it comes to debentures, it's different. Conceptually, debentures being a debt which the company owes the debenture holder is not supposed to remain in the company forever or for the entire life of the company. Now, that notwithstanding, the lawmaker is saying that it is still possible for a perpetual debenture to be created. What is a perpetual debenture? Perpetual debenture is a debenture which is created in such a way that is practically irredeemable. When we say redeemable, that is to say that the debenture holder can return the debenture to the company and then the company will pay his money and no other interest back to him or her. So that is a redemption. But the debenture may be crafted in such a way that is practically not redeemable, meaning that under no circumstance within practical range of society would the debenture holder ever have to collect his money from the company in terms of redemption and leave it. Or the redemption of it may be premised on a contingency, that is, an event which may never occur, or even if it will occur, it will not occur now. So let's suppose that you create a debenture and say that, okay, this debenture will be redeemable upon commission of the seaport, which a politician called Shedder or something said he will make at Kumasi by dredging the sea there. So when that seaport is commissioned, that is when the debenture will be redeemable. Now, if you look at that, of course, I'm not doing politics, but I'm just giving you what we call the impossibilities. If you look at that, it's not something which is going to happen anytime soon. It may happen, if it will happen at all, it may happen probably after another century or two. So you can use that contingency as the point at which the debenture will be redeemable. And as I said, this contingency is so remote. And for that matter, the debenture will be called perpetual debenture because practically the debenture will have the effect of remaining in the company for a long time or even for the entire life of the company, as it were, because the contingency which will need to happen for it to be redeemable is likely not to happen or will not happen anytime soon. So that is the point 87 is trying to make. Then we also have convertible debentures. Section 88 is to the effect that subject to Central Security Depository Act 2007 as 733, debentures may be issued on the terms that in lieu of redemption or repayment, the debentures may, adoption of the holder or the company, be converted into shares in the company on the terms that are stated in the debentures. Yeah. Before we move on, some of the provisions say subject to the Central Security Depository Act. And I hope you've not forgotten what the Central Security Depository Act is to do. When we're discussing share certificate, we'll talk about the concept of dematerialization, right? Where companies whose shares are governed by the Central Securities Depository Act regime have their paper shares certificates converted into digital or to numbers, as it were. So for such companies, you don't use paper or share certificates. They've gone paperless, so to speak. So that is what we are trying to say here. And the same things apply to the debenture certificate. So companies which have also gone to the CSD regime, that is the Central Security Depository regime, they don't have to issue the paper certificate. I mean, but convertible debentures, as we have noted, convertible means that I can change, convert from the word conversion. You can change from being a debenture to a share. So that is the point. And where it is created, that possibility will be stated that under the following conditions or when this and this happened, or at this particular time, the debenture holder may exercise an option, may elect, or the company may exercise an option and invite the debenture holder to have his debentures converted into shares, so that he will not just be a lone creditor of the company, but he will be one of the members or shareholders of the company, as it were. Now we come to another important aspect of debentures, and discussion of debentures oftentimes revolve around here. So let's pay attention well. Do you have a class today, or this is the only class you're having? Class rep, do you have a class today? Where's the class rep? Okay, let me release you. Yes. Ezekiel. You
have a class. You have a class today, sir.
Oh, okay. At what time?
12:30.
Oh, right. Okay. So. All right. So I'll stop at 12. Right. So secured or unsecured debentures, it has to know the distinction is premised on security. Whether security is given by the company to the debenture holder. And what is the point about security? A debenture is a credit, it's a credit arrangement. A debenture holder is giving a loan to the company. And if you are a lender and you are giving a loan to someone, or even among your circle of friends, if someone asks you for money, if you have the money, you may be cautious because you want to be sure, will this person be able to pay the money back? And of course, in life, one of the most annoying things is where somebody says that, give me a loan, and he or she will not pay it back, and you are forced to give it to the person as a gift. That one is not good. If you are going to give a gift to the person, right from the start, let it be a gift, but you shouldn't be, yeah, somebody's hand is up. See. Yes. Somebody is called Pretty V. Yes, let's hear you.
Hello, sir. Please, this is Nanaya. I was talking to the lecturers at the time my name was mentioned. He just called me back to say the lecture starts at 12. So,
Okay.
all right, sir.
Okay, so let me do this. What is